22-182-752. This is Silverlink Resources LLC versus City of Detroit. The matter is set before the court for a pretrial conference. Your appearance for Silverlink, please.
Good morning, Your Honor. Joe Yatuma on behalf of the plaintiff.
All right, good morning to you as well, sir. Did you put your P number in there?
Sure, 80627.
All right, thank you, counsel. For defendant City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Patrick Cunningham on behalf of the City of Detroit. My P number is 67643.
All right, thank you, counsel. Good morning to you as well. It looks like this is the date set after scheduling discovery and items along those lines prior to today's date. And so update me on where you are with these matters. I do see that some documents have been submitted. I don't see any motions filed at this point. So go ahead and update me.
Your Honor, I've never received a copy of the order opening discovery. I'd like to ask for 60 more days to do discovery. In the meantime, I have a facilitation scheduled in the underlying claimants case, LaKenya Page, on November 10th. And I spoke with Mr. Yatuma today about having this case facilitated on that date as well. So I think we're going to try and do that also, if that's all right with the court.
That makes sense to you, sir?
That is correct, Your Honor. We'll participate in the facilitation to hopefully resolve this matter. I believe it's scheduled for November 10th.
All right, so I will extend the order previously granted in this matter, and it will allow for discovery through the 23rd of November. So I'm setting you to come back on that date. Is that, can I do that now?
All right. On 11/23.
Yes.
We really didn't have any cases that day. The day before Thanksgiving. Want to do 28th?
28th, November 28th will be the next action date regarding this matter. I'll go ahead and set it on for 9:45 on the 28th of November. And that's taking into mind the things that that you talked about visually regarding facilitation. But again, discovery is open through that time, that I'll revisit the matter to see where the parties are by the end of the doctor's office. We'll figure out what to do. All right. So 11/28, 9:45 a.m. A new notice will be generated regarding that time, and the order granted by the court in this matter will be extended through that.
Thank you, Your Honor. Thank you, Your Honor.
Thank you. Good day to you.
You too.
You too.
All right, the court now calls case number 21-142-677. This is Sun Secured Financing versus Janet Vanderbilt and David Vanderbilt and the garnishee defendant in this matter, Apex Tax Solutions LLC. The matter is before the court regarding post-judgment matters of garnishment. This matter was not on the court's generated schedule, but I do see that there is documents indicating that there have been various filings. And so I understand that the parties may very well be here as well. Your appearance for plaintiff in this matter.
Good morning, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, P59383, appearing on behalf of the plaintiff.
Thank you, Mr. Sosson. Good morning to you. Do I have anyone here regarding the Vanderbilts? I know that counsel for Apex is here. I'm going to go to him in just a moment. Whoever that is. Anybody for Vanderbilt on this matter? Your appearance. All right, for Apex Tax Solutions LLC.
Good morning, Your Honor. John O'Shea, P52009 on behalf of Apex Tax Solutions.
Thank you, Mr. O'Shea. Good morning. To
Good
you,
morning.
sir.
Good morning, Your Honor.
So what's, update me, looks like, there was some, notice. The notice of garnishment, whatever the case may be there. Go ahead and talk to me this time.
Thank you, Your Honor. Yes, Your Honor, there was a writ for periodic garnishment that was issued by the court in proceeding. The writ was issued to the garnishee, to the defendant, Apex Tax Solutions LLC. And that writ for non-periodic garnishment was issued subsequent, of course, to the entry of a judgment that was entered against Apex Tax Solutions LLC, and that judgment was entered on May 5 of 2022. Subsequently, that writ for non-periodic garnishment was served on the defendant, Apex Tax Solutions LLC, and subsequently a garnishee disclosure was filed by the garnishee Michigan First Credit Union in relation to this non-periodic writ that indicates that the amount to be withheld by Michigan First Credit Union pursuant to the writ is $9,228.57, and that garnishee disclosure is dated September 8th of 2022. Subsequently, Your Honor, it appears that our office received an objection to the garnishment and a notice of hearing. The defendant indicated in the objection is Janet Vandabili, and it indicates the garnishee's Apex Tax Solutions. I do note, however, that there's no signature contained in this objection to the garnishment, nor is there a date. The only basis for the objection by this defendant is that the defendant objects to the writ issued on 9/8/2022, indicating that the writ was not properly issued or is otherwise invalid because writ was never served, no money owed. And that's the basis for the objection. Again, there's no signature of the defendant on the copy that I have. This was subsequently set for a hearing for today's date. And so it would be plaintiff's position that the garnishment was properly issued to this garnishee defendant. The writ was properly served, and that the defendant simply has no valid basis to the objection to the issuance of the writ. And as such, we would respectfully request that the court deny this defendant's objection as invalid. And finally, I would note for the record as well that this particular defendant failed to appear here today to advance this defendant's own objection to the garnishment as well. And so for those reasons, respectfully, the plaintiff would request that the court deny the objection as invalid. Thank you.
One more time here. Do I have Janet Vanderbilt on the Zoom? If you're on the Zoom, anywhere, please say something at this time. If you're on the Zoom and you're on mute, you can hit *6 and that should take you off of mute. I'm looking for Ms. Janet Vanderbilt. If you're on the Zoom, say something at this time. Councilor, you indicated two entities as it relates to the non-periodic garnishment, and you indicated a credit union or something, and then you, of course, you indicated Apex. Are there more than one, or is there more than one garnishee defendant interposed herein?
There is a income tax writ was sought for issuance as well, Your Honor. So yes, the Michigan Department of Treasury is also a garnishee as well, pursuant to a writ.
Okay, I do see that. I do see that. And all I have is a register of action. Unfortunately, the file did not populate to me today. So the only thing that I have in front of me is a register of action. But in your communication with the court, you talked about Apex, but in talking about Apex, you mentioned that there was you mentioned a bank or something.
Yes, Your Honor. A writ for non-periodic garnishment was issued by the court in this case on August 17th of 2022. And again, just to back up as well, the court entered a default judgment against Apex Tax Solutions LLC on May 5 of 2022. And so subsequently on August 17th of 2022, the writ for non-periodic garnishment was issued. And the garnishee in that writ is Michigan First Credit Union. And as a result, after that writ was served, the garnishee, Michigan First Credit Union, filed the disclosure on dated September 8th, 2022, indicating that the amount to be withheld is $9,228.57. We haven't yet received a payment, but does that answer the court's question?
So Michigan First is the name for Apex. That's what you indicate. All right, got it.
Yes, Your Honor.
Mr. O'Shea, go right ahead, sir.
Thank you, Your Honor. Yes, Your Honor, I represent Apex Tax Solution. I was just recently retained. I filed my appearance yesterday with this court. The problem with the garnishment, Your Honor, is the underlying judgment is not valid against Apex Tax Solutions. My client was served with a garnishment. The woman, Janet Vandebeen, was no longer working for my client. My client told that on numerous occasions to the plaintiff's counsel. The subsequent interrogatories and motion, my client did not receive any notice of. So what my plan, Your Honor, is to file a motion to set aside the underlying default judgment as it was improperly entered. First, there is absolutely no basis to conclude that my client owes any money to Ms. Vandebeen because she was no longer working for the company at the time the garnishment was served. And we have documents and facts that can prove that. So there's clearly a meritorious defense. There's certainly good cause to set aside the default because there was no notice ever given of the motion for default. So my request, Your Honor, at this time would be to adjourn the objections to the garnishment to Apex's bank and allow me, being just retained, to file the appropriate motion to set aside the default judgment in front of Your Honor so you can decide the merits of this case.
All right, yeah, I mean, obviously, you can't really argue that today, but that's not for me. Mr. Slauson, counsel has indicated to me that he wishes the court to engage him in regard to an adjournment so that he might file a motion that he believes would be responsive on this issue. Counsel.
Thank you, Your Honor. I certainly understand counsel's position, but in kind of just reviewing the procedural history of this case beyond defendant's objection here today, I would note as well that there was a motion to compel garnishee interrogatories that was filed in this case, properly served on this garnishee. And as in reviewing the history as well, I would note as well that there was a hearing on plaintiff's motion to compel. It was served on garnishee on April 5, I believe, April 5 at 9:45 a.m. And in reviewing some notes, I didn't attend, but in reviewing my colleagues' notes, I understand that the court granted the motion to compel, but had reserved a decision on attorney's fees for the next hearing. The court then scheduled another hearing on May 5, 2022 at 9:30 a.m. to determine if she had answered the interrogatories. And I understand as well that the garnishee failed to appear at the hearing, at the subsequent hearing in this case. And at that time, the court entered, court entered a default judgment on May.
Thank you for the recitation of the procedural history regarding this matter. Obviously, neither party is really in position to argue the nuances as it relates to the entry of default judgment. There is in fact a default judgment that was entered, and obviously that is consequential. So I take that there is the issue of the entry of that judgment to be litigated, and Mr. O'Shea has indicated he intends to file a motion, so that does make sense. In the interim, we got a valid writ issued upon a judgment that's been entered. And so my inclination would be to have those funds released in escrow in some kind of way. But have you gentlemen put any thought into that? Because it seems like that is where this should go at this point, and then I'll hear the motion and make a decision as to which direction the funds would go, whether they return or whether they go to plaintiff in this matter. I'll hear your thoughts on that, Mr. Salson.
Thank you, Your Honor. Well, Your Honor, it would be plaintiff's position respectfully that Garnish's filed nothing at this point. So I think in all fairness, it would be premature to place any of those funds into escrow at this point based upon counsel's indication that that Apex may file a motion to set this aside. At such time, if that motion is subsequently filed and the court then sua sponte or on an ex parte basis deems it appropriate then to place the funds in escrow, I certainly would understand that. But again, nothing's been filed yet at this point. And I just kind of wanted to briefly respond procedurally as to what's transpired in the past. I know counsel just briefly argued, hey,
I'm going to stop you there because we will go on and back and forth with it. I mean, whatever the procedural history is, I mean, the court's going to look at that. And if there was a failure to respond to that timely, then those factors will clearly play into number one, whether or not the default will be set aside, and then number two, if the default is set aside, whether or not there is an appropriate issue of assessment of costs or anything along those lines. So all of that will come up. Mr. O'Shea has been he has indicated more than a suggestion that he's going to file a motion. He's indicated that he intends to do so clearly in that he has indicated the prongs upon which he would file such a motion. Your thoughts on, I know that the funds are held at the bank. Your thoughts regarding pulling that out into some type of escrow scenario, Mr. O'Shea, your thoughts on that?
Your Honor, my understanding, and Mr. Lemon, the owner of Apex Tax Solutions, is on the call. My understanding is it essentially is in escrow. It is frozen. My client has no access to that money. He has spoken with the bank, and the bank has said they are holding that money essentially in escrow until this thing is resolved because they don't want to get caught in the short hairs between either one of them. So my understanding is it's already in escrow. If Your Honor is more comfortable to actually moving the money into escrow, into my trust account, that's fine, or an escrow agent. But my understanding, Your Honor, is it is essentially already in escrow, and that, the situation has been properly frozen so that plaintiff is not damaged. If we lose on the motion for default, to set aside the default, they get the money. And if they don't, and if we prevail, Your Honor, we get access to the money and we can proceed on if they want to serve discovery or whatever. So I think the matter is frozen at this point, Your Honor, to properly take a little time just to make sure that this money is owed, which the facts I know it clearly is not. But I know that's for Your Honor's determination at a later date. But in sum, and answer your question, Your Honor, I think the money is frozen, and I know we have no access to the money at this point.
Yeah, I know it's frozen, and the question becomes, whether or not to establish some type of escrow agent, because that's not what the bank is. The bank's not the escrow agent right now.
Right.
So I want to keep the funds, if you will, encumbered until this is decided. Obviously, that's the goal. Towards that end, if everybody's confident that if I sign and that I can sign an appropriate order that will cause the bank to act something the nature of an escrow agent, because they're not real fond of doing that. They're just freezing funds right now because there is a garnishment in place. So what I'll do is I will maintain the status quo and adjourn the hearing on the objections to the garnishment. And so the status quo is maintained at the bank. The objections to the garnishment are adjourned, and the court will set the matter over for hearing. I'm going to set, how much time do you think you need on this? I want to give Mr. O'Shea opportunity to file his motion, and then some opportunity to answer, but then I don't want to delay this too far out. So Mr. O'Shea, how long before you think you might be able to get your motion answered?
Your Honor, I could get a motion on file within 14 days. That's agreeable to the court.
All right, that sounds good. And 14 days to respond to that, Mr. Salston, sir?
Yes, Your Honor, please. Thank you.
So I'm going to go ahead. I'm going to go ahead now and set the matter on for the. Let's go ahead and set it for maybe the 21st of November. I can bring it a little sooner if you want.
It's fine with plaintiff, Your Honor.
All right. So November 21st, if that works for you, Mr. O'Shea.
That's fine, Your Honor.
All right. So November 21st at 10 o'clock a.m. And somebody email me an order maintaining the status quo, if you will, and adjourning the objection to garnishment. And you can email that to, I'm going to give you an email address. That's Latifah, LATIFAH .hunter@33636th districtcourt.org.
36 District Court or 36 District Court? TH,
Yeah, 36th, yeah.
District Court
Or,
.org.
all right, so get that over to me. Get that over to me right away. There will be another notice generated for that date, but you can go ahead and put the notice of hearing date on there as well, November the 21st at 10 o'clock a.m.
Your Honor, and put the briefing schedule in as well.
You can put that in, but you guys, no.
Okay.
You don't have to put that much into the paperwork. You know
Okay.
that this is adjourned for a hearing on a pending motion. So whichever way you choose to do it, get your motion filed. You got plenty of room there. Get your motion
Yep.
filed, any answer filed. If you want to do an answer to the answer, so on and so forth. That's why I gave a little bit of extra time. Go ahead and fight it out. Put as much as you want to put out there. And I'll take a look at it and we'll do a hearing on it. And I'll make a decision on the outcome.
All right.
All right,
Very
gentlemen.
good.
Good day to you.
Thank you.
Christopher, you want me to do that?
Will you prepare that, Mr. O'Shea?
Yeah, would you mind giving me your email address?
Absolutely. It's
You can
C.
chat it. Want to chat it to them, or you can go ahead and give it to them, whichever way you go.
Okay.
Go ahead.
It's CJS@velo.law. CJS@velo.law.
Great, thank you. Thank you, Your Honor.
You're welcome,
Thank
counsel.
you, gentlemen. Good
Thank
day
you,
to
Your Honor. Thank you. I have one more case with Your Honor, so I'll just stay in Your Honor.
All right, thank you, sir.
You're welcome.
All right, this is case number 21-169806. This is AutoVest LLC versus Erica R. Ray. The matter is before the court on the following objections to a writ of garnishment. The record should reflect in this matter the judgment was entered by default on the looks like the 10th of January 2022. The judgment is for $5,545.83. Subsequent to that time, of course, the plaintiff sought to enforce the judgment by way of filing a writ of garnishment. This affects those in the oath. Your appearance for AutoVest, please.
Judge, may I please court, my name is Attorney Richard Bruson. My bar number is 35222. I'm the attorney of record of the plaintiff, and today I am the respondent to defendant's objection to a wage garnishment.
Thank you, counsel. Good morning to you, sir. I'm looking now for Ms. Erica Ray, if you're on the Zoom, please say something at this time, Ms. Ray. I see I see something, Erica's phone. If you're on mute, push *6, that should bring you off of mute. Is that Miss Erica Ray? Ms. Ray, if you're having difficulty, ma'am, hang up real quick and dial back in. All right, so I see Erica's iPhone, but I'm not getting a response there. Did you have any contact with the Erica Ray this morning at all?
No, not at all, Judge. I mean, previously, I'm sorry, she previously called my office in September twice, 3 times, but nothing today, nothing since October rolled around. And so that's all I can tell you, Judge. I don't understand her objection, and I was hoping she could broaden the record out with her testimony.
Right, because she only puts on here, I was never served. And,
Yeah.
That
Now-
of course would.
Now, Judge, if you want, I've got a lot of chamber work to do. If you want to put me to the back of the dock and see if she maybe picks up, maybe she's walked away from her iPhone. I don't know.
All right, thank you. Thank you, Mr. Rule. That's a good suggestion. I'll go through a couple other matters. I'll come back to you, sir.
All right, I'm gonna go on mute, Judge.
All right, thank you, sir. The court now calls case number 19-161996. This is Manistee Acquisitions LLC versus Fahima Curve. The matter is before the court on the following objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter by default. The total amount of that judgment is $1,247.03. The plaintiff sought enforcement of the judgment by filing a writ of garnishment as to Martha T. Berry Medical Care Facility. Your appearance for Manistee Acquisitions, please.
Good morning, Your Honor. Christopher Sosson, spelled SOSSONG P59383, appearing on behalf of the plaintiff, Manistee Acquisitions LLC.
Thank you, Mr. Sosson. Good morning to you again, sir. I'm looking for Fahima Curve. If you're on the Zoom, please say something at this time.
I'm here, Your Honor.
All right. Good morning to you, Ms. Curve. I looked at
Good
your
morning.
objections to the writ of garnishment. It says, I do not know who Manistee Acquisitions is and did not sign a contract with the plaintiff. That sounds like an effort to attack the underlying judgment in this matter. And the rules really don't allow you to do it that way. This is post-judgment, and this is giving a reason why the garnishment should not issue, given that there is a judgment in place already. That's why the categories are there. This is a type of action that you would point out that you filed for bankruptcy or that the judgment's paid, things like that. But if you're attacking the underlying judgment, you have to file a different type of proceeding to do that. So tell me, in light of that, ma'am, tell me what's going on here. Is there some money that you owe to some agency that may have transferred this to Manistee? Because I have on here, also known as Why Not Leasing LLC. You familiar with Why Not Leasing at all?
No, sir.
Okay. All right. So, counsel, let me hear from you then regarding this matter, sir.
Thank you, Your Honor. This is, as it relates to defendant's objection to the garnishment, it is plaintiff's position that the defendant does seek to attack the underlying validity of the judgment itself, which is prohibited by MCR 3.101K1. which expressly states that an objection to a garnishment may not be used as a vehicle to attack the underlying validity of the judgment itself. But that being said, it is also plaintiff's position that this suit began with the commencement of the filing of the summons in the complaint. And attached in support of that complaint is evidence of the agreement that was entered into by the assignor and the defendant. And that agreement, again, was attached as an exhibit to the complaint that commenced this cause of action. And subsequently, the defendant also was duly served pursuant to court rule by personal service of process on July 26th of 2019 at 10:33 a.m. I note as well in viewing a copy of the proof of service that was filed with the court that the defendant was served at the very same address that she's listed in her objection, which is 20191 Spencer Street, Detroit, Michigan, 48234. So defendant was properly served with the summons and the complaint so as to respond to file a response of pleading to the summons or to plaintiff's complaint regarding this cause of action. Defendant failed to do so. And so subsequently, a default judgment was entered against the defendant by the court on August 23rd of 2019. And a copy of that default judgment was subsequently served on the defendant. And the defendant thereafter took no action to file a motion or any other action to seek to set aside the default judgment or to contest the underlying validity of the judgment that was entered against her. And so subsequently, the defendant files a subjection to garnishment here today, seeking to attack the underlying judgment itself. It's not proper, but just as an explanation, it is plaintiff's position that this suit was well grounded in fact and law. A copy of the agreement that formed the basis for this was also attached in support of the complaint that was filed in this case. It is plaintiff's position the entry of the judgment is sound, and again, defendant's objection to the garnishment is improper pursuant to MCR 3.101K1. Accordingly, plaintiff would respectfully request that the court deny her objection as invalid. Thank you.
This seemed to be something that this seemed to be something that related to the lease of a computer or some computers electronically. So, all right. I'm not laughing about this case in my clerk. All right. So, yeah, this seemed to be related to some computer equipment that allegedly was leased, and there seemed to be no activity after this was served and after judgment was entered. Ms. Kerr, why did you file something or anything after you received the judgment in this case? You did nothing until there was this garnishment.
Your Honor, this is my first time acknowledgement of the garnishment. I didn't receive anything by hand or anything like that in 2019 because I wasn't even staying there. That's my property over there on Spencer Street. So I wasn't even there in 2019 to get anything in my hand. So this is my first time me actually seeing this. This is my first time ever getting garnished. So in my life. So, and they're taking 25% of my check of something I don't even have. And I'm a single mother doing this by myself.
Gotcha.
So,
Gotcha.
and again, I did not get anything properly in my hand or
I'm
anything.
not listening now. Let me stop you. We'll get to that part. The issue here starts out with there being a judgment against you. And that address on Spencer is where all the documents would have been sent and or delivered. If you believe that this judgment should not have been entered against you, you have to file a proper motion to address that issue. of the judgment being improperly entered. That's not before me now, so I can't even visit that, because in the file, I have a proof of service, an affidavit signed by someone saying that you were served, and I have the fact that the judgment was mailed out to that address after it was entered. And no response, nothing was said until the writ of garnishment was filed, and that's when you file something in response. So if you're going to file something, man, you want to file, I suppose, something like a motion to set the judgment aside because you believe that it shouldn't have been entered, and you have to show reasons why you believe that should be the case, and reasons why you waited till now to act upon that. As it relates to the garnishment, I don't find that there is a valid objection. So any funds that have been withheld, I'll release those funds to the plaintiff. Now, the question becomes, ma'am, I know that you would like to have that garnishment suspended. So what can you pay on a monthly basis in regard to this? So maybe we can talk about suspending the garnishment so they're going to take 25% of your salary.
Well, Your Honor, I can afford maybe $100 a month, but I can't afford the almost $400 out of my work check every 2 weeks.
Yeah, so they basically take it from you about $800 a month, correct?
No, they just my last check they took out almost, it was like $343, and then when I looked at it again today, because I received my payment on Friday, it's another $343.
Okay, so roughly about $700 have been taken from. Okay, so counsel, how much do you have as the balance here? Have you acknowledged or received any of those two garnishments?
Well, Your Honor, in answer to Your Honor's question, the current judgment balance is $1,397.46. Additionally, I would note that our office has not yet received any garnishment payments at this point in time.
All right. So what I'm going to do is I will release, Ms. Kerr, if you will, tell me the exact amount of those two notifications that you received regarding how much they took out, 300, how much, man?
Okay, so because I'm looking at my pay stub. So the first amount they took out was, this was for 9/23/2022.
Okay.
The garnishment was $374.83. And for the paycheck for 10/7/2022, they took out $343.13. But I can see my pay stub like early Wednesday, but I don't receive my pay until Friday.
Gotcha. Yeah, I understood what you were saying. So if we look at those numbers and let's just try to get some estimate of where everything might be right now. So we look at those numbers in $717.96. So, I mean, that's like half of the judgment that will get paid. You only owe somewhere in the nature of a little over $700 if those amounts are applied. So I will certainly allow you to pay the $100 a month, ma'am. I'll suspend the garnishment. So the funds that they already took from their last paycheck to this paycheck, I'll allow those funds to be released to the plaintiff for those awards paying off the judgment. But then I'm going to suspend the garnishment, allow you to start making payments of $100 a month, and that will that should grant you some relief. So the way I'm going to set it up then is your next payment will be due on the. You want me to put it the 28th of November, or excuse me, 28th of October, 4th of November?
Yeah, my next pay is on the 21st.
Yeah,
So
but,
they,
yeah, I mean, Because there's been a couple of garnishments, I want to start the $100 payment. And I was thinking to start it on the 28th, but do you want to wait until November the 4th?
No, I'll start on the 28th.
Okay, all right. So I'll stop the garnishment right away. I'll set up an order for you to pay the $100 on the 28th. You shouldn't get any more garnishments after this pay period. That's gonna stop. Then you make the voluntary $100. And you basically shouldn't have but seven payments, 7 or 8 payments at the most. And then this should be satisfied. You understand?
Yes.
All right, so I'm gonna set it up that way, and you still have the right to file a motion to try and get this set aside if you wanted to. File that motion. If you prevailed on the motion, then you would be entitled to refund of any money that was taken. But if you believe that this has something to do with some equipment that was rented and what have you, then you may not want to proceed that route. I mean, that's up to you. I don't know what the facts and the details are. I just know that you have a judgment against you. And so I'm going to grant you that relief, ma'am. You'll get an order from me stopping the garnishment after this pay period. And you'll want to make sure that you take that to your payroll department so that they will have the documents to no longer take any money out of the check. They'll be paying $100 voluntarily, with the first payment being on the 28th of October. You understand, ma'am?
Yes. Do I, how do I receive that paperwork? Do I get an email? Do I come pick it up or?
Well, I was gonna mail it to you, but I'll tell you what, we're gonna mail it out, but I'll tell you what to do. You know how to chat your email address? If you will put your email address in chat, in the chat, I'll have my clerk to send a copy to you by way of email.
Okay.
Okay.
Thank you.
Go ahead and put that in the chat. We'll get a copy off today. And the garnishment will be stopped after the 7th.
Okay. Thank you, Your Honor.
All right, so wish you well. That is my order, Council. You get copies of the orders as well, and all the best to you.
Thank you very much, Your Honor. Same to you. Thank you, ma'am.
All right, I'm looking for. Looking to see if I have Miss Erica Ray. Are you on this Zoom, ma'am? Say something. Erica Ray. All right, this is case number 14-102-164, Portfolio Recovery Associates LLC versus William L. Cook. The matter is before the court on the filing of objections to a writ of garnishment. Do I have counsel for Portfolio? Do I have William Cook? Mr. William Cook? All right, this matter is set on for a hearing on the objections to the writ of garnishment. On today's date, it appears that neither party has appeared, and more specifically, the defendant did not appear objecting to the garnishment. For that reason, the objections in this matter are denied. So I'm seeing Mr. Reginald Harvey indicating, are you on, do you have something in this courtroom?
Yes,
What do you have?
yes,
sir?
I do.
What do you have?
I'm right here, sir.
Yeah, what is your case number?
I don't know my case number, sir.
All right, what is your case about, sir?
It is about at the Roberts Riverwalk Hotel. A gentleman assaulted me and assaulted the lady that books the people into the hotel.
All right, yeah, you're in the wrong courtroom. Is this your first time coming to court on that matter?
Yes, sir. I was supposed to be with Judge Bryan. I had been waiting since 9 o'clock, and Judge Bryan came on, and they had me on hold, and I've been on hold ever since.
Okay, well, we gotta get you back there because this is a civil courtroom. All I deal with is lawsuits. And
Oh, okay.
so you're in the wrong courtroom. Let's see if we can get Judge Bryan's Zoom number. and get you-
Brian, they're in, Brian.
Yeah, I don't know how I got switched over.
339.
Go ahead.
So it's 360339.
360. Yeah, that's 339
So,
0000.
yes.
Yes.
That's what
So
I've
this is-
been dialing all day.
Well, yeah, that's 339. This is 336.
Oh, okay.
Sure you putting that 9 in there. 339.
Yes, sir.
And if
And I thank you, sir, and you have a blessed day.
If they give you a problem, tell them you were in Judge Coleman's courtroom by mistake, okay?
Yes, sir. Thank you, Judge Coleman.
Thank you. Good day to you.
Yes, sir. I'm trying to get off this courtroom. Trying to get out of here. Let's shut the phone down and go back.
All right, Miss Ray, I see your phone indicator there. It says Erica's phone. Ma'am, if you have a problem unmuting yourself, then simply hang up and call back in, ma'am. I'll wait for you, but you gotta go ahead and do that now. Just hang up your device and call back in.
Yeah, I got it.
Take care.
Yep.
Email address.
Okay. Her email.
Yeah, I was talking to you. I sent a chat to Erica's iPhone. I'm not hearing anything. I see the phone still indicated there.
Yeah,
And I've called out several times, so I don't know what's going on there.
yeah.
So it doesn't, it doesn't appear regarding 9806, Mr. Rose, it doesn't appear that there is any.
Yeah. Well, Judge, I don't want to usurp your role as the prior fact, but maybe if the court adjourns this objection with a new written notice, maybe perhaps 2 weeks from now, maybe that'll be useful. But that's all I can suggest.
Well, that's a good suggestion. The challenge, of course, is that it looks like that maybe Ms. Ray trying to get in, whatever. The other challenge is that the objection on his face doesn't seem to have any validity to it. But the better approach is to give it another shot and see if they.
Yeah. Well, as a Roman Catholic, I believe everybody's entitled to redemption. So, so I'll stipulate to adjourn for 2 weeks.
All right, we'll set it over, 2 Wednesdays from now.
Wednesday. Yes, October the 19th.
Yeah, October 19th,
That sounds great.
9:30.
All right, we'll see it on the 19th, Judge. Thank you.
Thank you, Council. Good day.